Oh, yay, oh, yay, oh, yay. This Honorable Court of Appeals of Tennessee is now in session. God save the United States of America, the state of Tennessee, and this honorable court.
Good morning. Before we have Mr. Hibner call the case, a couple things I want to say. We don't anticipate any technology-related problems, but if we should have any, everybody just take a deep breath and relax, and we'll work through it. We understand the situation. Mr. Hibner, call the case, please.
City of Morristown et al. Versus Michael W. Ball et al.
We're here from the appellant.
Good morning, distinguished panel. My name is Kevin Harden of Butler, Vines and Babb. I represent the appellants Michael Ball, MPLG LLC, which I will refer to as the LLC, and MPLG Trust, which I will refer to as the trust. And before I get into the salient facts of why we're here, I again want to replicate the standard of review on a motion for judgment on the pleadings, which I'm sure this court is very familiar, but it's important for me to emphasize that to demonstrate why His Honor the Chancellor Jenkins was an error here in granting the motion. You know, when a court is faced with a 12.03 motion, the appellate court, after the grant of the motion, is bound to regard as false all allegations of the moving party that are denied by the non-moving party, and to accept all well-pleaded facts of the non-moving party as true and all of the reasonable inferences therefrom. And it's the reasonable inferences that are the key here. Especially where conclusions of law aren't admitted, nor should judgment on the pleadings be granted unless the party that prevailed is clearly, and I emphasize the word clearly, entitled to judgment. As long as the defendants here are able to prove any set of facts to the contrary on the pleadings, then the motion shouldn't be granted. And my client should be given every benefit of the doubt when they oppose the motion. This is simply a question of law. This court reviews it de novo. And when reviewing, this court is required to liberally construe the pleadings. Can't do it in an artificial technical sense. Construe the pleadings as the Methodist healthcare case says, fairly and naturally, and give effect to the substance rather than form. The whole key is whether the party that filed the motion was put on notice by my client's response. The facts seem complicated, but really they're relatively simple. And they are closely traced through our brief, through Mr. Kaiser's brief, through Ms. Carroll's brief. But here are the keys. This all started with an asset purchase agreement between the LLC and initially the city, now the commission, for the sale of a wastewater treatment plant. And under that document, there were a stream of payments, which are referred to of the flow fees, that would be paid by the city to the LLC. Later on, there was an unfortunate divorce between the members of the LLC. As a result of that divorce, contemporaneously entered into were a global settlement agreement and a trust agreement. And those documents are appended to the cross-claim by Renaissance Bank. But under that, if you wade through it, it's pretty simple. The city pays the LLC. The LLC then pays that money to the trust. Then the trust allocates those payments between the members of the LLC. That was ongoing. That was the practice. City paid the LLC, LLC paid the trust. The trust then distributed the money to the accounts designated by my client, Mr. Ball, and the other majority member, Mr. Fielden. Later, Mr. Ball goes to Renaissance Bank and borrows the money. The bank attorneys prepare the documents. The bank attorneys have the benefit of all of those documents. But one of the key provisions in the loan document is recital J, and that's at, I believe it's page 83 of the record. But in any event, that document says these loan documents are governed by the asset purchase agreement and the trust agreement.
Pardon, I'm sorry to interrupt you. Can we go back just a second to,
Sure.
I think what you had said was that per the agreement, the city was to pay the flow fees directly to the LLC and the LLC then paid them to the trust. But I
Correct.
think that Mr. Kaiser's brief, and he may be able to clarify this for me, but I thought it said that the payments went directly from the city to the trust account.
Right.
Am I
But
wrong about that?
that's what the document says. Okay.
Okay.
And I agree that that's what the document says.
Okay.
But the city was not a party to that agreement. So the question is, what does that language mean? Okay. And that's, again, one of the reasonable inferences point, because the city never paid the trust directly, ever, not one time. It always went to the LLC. And with the city or the commission not being a party, then they can't, the parties to the global settlement can't change the city's obligation without the city being a party to that contract. And it was the understanding that it was always that way. City to the LLC, LLC to the trust, trust to the designated accounts.
Thank you.
And that's one of the very important things when we get to the loan documents, because the loan documents, again, prepared by the bank, says it's subject to the asset purchase agreement. It's subject to the trust agreement. There's no question Mr. Ball defaulted on the note, but that's not why we're here. The only question related to what happened to the sale is, why didn't anybody show up at the sale other than the bank? This case needs to have proof for that very reason, because one of the keys is, not one of the keys, probably the main key is, based on these documents, what did Renaissance Bank have a security interest in collateral wise? That's one of the key disputes. Here's another issue. The city decided that it had overpaid the flow fees, so it suspended payments. And during the period of time that the city suspended payments, First Tennessee Bank, who held the trust account, closed the trust account. Then later, both trustees resigned, Mr. Dessauer and Mr. Little, who are very good lawyers. Then the trust agreement allows the trust to be terminated in the event that the bank ever made direct payments to Mr. Fielden, which it began. So based upon that, Mr. Ball then terminated the trust. That's in the trust document, which again, the loan documents say are governed by the trust document. So there's an inconsistency in the bank's own language. It says you can't terminate without trust, but at the same time, it's subject to the underlying agreement. The bank says that Mr. Ball, the trust, and the LLC admitted certain provisions. No, they didn't admit certain provisions. We've set it out in the reply brief. It said the documents speak for themselves. Then the question becomes, what do those documents mean? And it's not from a parole evidence rule. It's just, what does the language of those documents mean when read all together? And it may very well take expert proof from somebody who is extremely experienced in secure transactions to say what in fact is the collateral that the bank holds. The last
Counsel,
Yes, sir.
What do you say those agreements, how the agreements answer that question you just stated?
That based upon the status of the pleadings, that the bank did not have a security interest in the direct payment from the city to whatever got in Mr. Ball's hands. If you look at the loan documents, the Ball payments are governed by the trust documents.
All right, I understand, but tell me, what did the bank have a security interest in? Your argument is, what did the bank, tell me what the bank had a security interest in under the documents?
That's the question, but it is not in the payments that were interpleaded into the court, where the city's saying, where do I make these payments?
But you can't tell me what your position was as to what the bank had a security interest in?
All right. I would say, Your Honor, that the bank had the security interest in the trust accounts distribution to Mr. Ball.
And Mr. Ball dissolved the trust?
Dissolved the trust after the bank began making direct payments. I'm sorry, not the bank. The city began making direct payments to Mr. Fielden.
And only to him?
Only as to him. Then what also needs to be developed in the proof, it's pled, albeit not a verified pleading, that Mr. Ball offered to say, hey, Renaissance, let me give you part of my payments. And they wouldn't accept it.
So
there's an exchange of letters.
I'm sorry. So by the pleadings, was Mr. Ball receiving payments directly then?
No, sir. No, Your Honor.
So
he was not receiving payments. The bank, during the course of the suspension of the payments, the city suspended making payments. And then after that occurred, this lawsuit occurred after the foreclosure sale.
All right.
Okay. So then those monies were paid into the court. And the reason this is all important, and the bank says there's no proof in it, but again, reasonable inferences. If you look at the flow fees under the asset purchase agreement that ultimately would be paid to Mr. Ball through the term of that agreement, it is at least twice from what his debt was that was bought at the foreclosure sale. So there is an absolute windfall to the bank. Now, without expert testimony, you can guesstimate it, but that amounts over $1 million when the debt due the bank from Mr. Ball was $590,000.
You've used your time, Mr. Harden.
Thank you, Your Honor.
You have your time for rebuttal. We'll hear from the appellees.
Please, the court, Morris Kaiser, representing Renaissance Bank. I'm off initially at the outset. Let me state that Ms. Carroll, counsel for the city and the utility, has authorized me to state that her clients agree with the bank's position in this case. All the facts stated by the brief and by the bank in its brief statement of facts in its brief were agreed to by the city and the utility, and all those facts were admitted by Ball, the LLC, and the trust, either expressly or by operation of Rule 8.04, based upon their failure to deny the allegations. Now, Mr. Harden has said, well, we said the document speaks for itself, which they did many times, but that's not a denial. So by operation of Rule 8.04, those allegations are treated as admitted. In 2009, Mr. Harden stated the city and the LLC signed the asset purchase agreement. It provided if those flow payments would be paid to the LLC. However, in 2012, that arrangement was changed. In 2012, Ball, the LLC, the co-trustees, and the trust signed the global settlement agreement. And it says expressly, all flow fees shall be paid by the city to a separate trust account established by the MPLG Trust for the benefit of Fielden and Ball, with one half of those fees transferred to a separate account for Fielden and one half transferred to a separate account for Ball. Contemporaneously, Ball, the LLC, the trustees, and the trust signed the trust agreement, which provides the trust account shall receive all future flow fees paid by the city, one half to go to Fielden and one half to go to Ball. Mr. Harden says the city didn't sign that agreement. It doesn't matter that the city didn't sign that agreement. Mr. Ball signed it, the trust signed it, the LLC signed it, the co-trustees signed it. The city agrees with the bank's position in this case, and it's not a problem as far as they're concerned. Then we go to 2017, when the most significant document in the case is signed by Mr. Ball. It's a document he signed with the bank, a collateral assignment and pledge and security agreement, Exhibit 4 to the bank's pleadings. Mr. Ball signed this document to induce a federally insured banking institution to make him a loan in the amount of $710,000. In that document, Mr. Ball represented in recital B that the trust is the sole initial recipient and acts as the conduit of all future installment payments of flow fees paid by the city pursuant to the asset purchase agreement. He represented that he is or will be entitled to 1/2 of the flow fees deposited in the trust, which pursuant to the trust agreement are immediately transferred to a separate bank account designated by Ball, which is defined in the security agreement as the right to payments. Let me pause here just a minute and point out to the court, neither in his opening brief or his reply brief, nor in his argument, did Mr. Harden say anything about recital B in the security agreement, wherein his client says that the trust is the sole initial recipient and acts as the conduit of all future installment payments and flow fees paid by the city. He hadn't addressed that, and I understand why, because it destroys his position in this matter. Ball represented in recital H that he understood and agreed that the bank was relying on his representations, warranties, and agreements. I'm glad Mr. Harden brought up recital J. It does not refer to the asset purchase agreement. It refers to the settlement agreement and the trust agreement, which, of course, those support the bank's position that the flow fees go from the city to the trust directly. In paragraph 1, under the contractual provisions of the security agreement, Mr. Ball said, all the recitals are true and correct and binding on him, and that all of his representations stated in the security agreement are true and correct. Let me pause here to say that the recitals, therefore, are not mere recitations or representations, but by virtue of that language, they are contractual agreements. All of those recitals that I just read. Then in the security agreement, Mr. Ball granted the bank a security interest in the right of payments. He agreed in section 6 that he would not, without the bank's written consent, amend the trust agreement in any manner that would adversely affect the bank's security interest in the collateral. He agreed in section 7 of the security agreement that he would not voluntarily withdraw as a beneficiary of the trust agreement without the bank's written consent. The co-trustees signed the security agreement to express their agreement thereto and their consent thereto. The next year, 2018, Mr. Ball, the document I've referred to as the Ball letter agreement, sent a letter to the co-trustees, and he said, I irrevocably direct that the full amount of all future payments that I am entitled to be paid under the MPLG trust be paid to Renaissance Bank. At its maturity in 2019, Mr. Ball did not pay his note, so the bank conducted an Article 9 sale to sell the collateral, which is defined in the security agreement as Mr. Ball's right to payments. The bank entered a credit bid of $599,691.26, which was the full amount due on the note. There were no other bidders. The bank, therefore, by operation of TCA 47-9-617, became the owner of the collateral. And significantly, very significantly, Ball's liability on his note was reduced to $0. As Mr. Harden indicated, First Tennessee Bank closed the account where the Ball payments were deposited due to lack of activity, apparently when the city withheld some monthly payments to recoup the claimed overpayment. Then when payments resumed, the bank's lawyer wrote the city's lawyer with copies to the trustee asking that the then current payment be paid directly to the bank and that the co-trustees establish an account with the trust into which these payments may be made by the city. The co-trustees then resigned. Then Mr. Ball purported to revoke the trust and demanded that the city and the utility pay the flow fees to the LLC, which was then an administratively dissolved entity. of which Mr. Ball claims to have 100% ownership. Mr. Ball's purported termination of the trust does not negate or relieve him from his agreements in Section 6 of the security agreement not to attempt to modify the trust in a manner that would impair the bank's collateral or voluntarily withdraw as a beneficiary. But more importantly, at the time Mr. Ball purported to revoke the trust, the bank already owned the Ball payments. They'd been acquired at the Article 9 sale. So the revocation could be of absolutely no effect. Mr. Ball has asserted, nor the trust, nor the LLC, neither has asserted any claim or right that would permit them or permit Mr. Ball to receive the Ball payments in derogation of the bank's ownership thereof. The bank's position is Mr. Ball is absolutely stopped to claim ownership in the Ball payments based on his agreements. This is the bank's position that Ball's purported revocation was done in an effort to defeat the bank's ownership rights in the Ball payments is in complete bad faith, is blatantly contrary to his promises in the security agreement and in the Ball letter agreement, in which he irrevocably directed the co-trustees to pay the full amount of those payments to the bank. Now, Mr. Harden has said that.
Let me ask you a question, Mr. If I'm reading the pleadings correctly, and perhaps I'm not, but in your motion for judgment on the pleadings, you list your initial analysis of why the bank should receive judgment on the pleadings. Then you list at least, if I counted them correctly, 6 alternative ways that the bank is entitled to judgment on the pleadings. I have reviewed the trial court's order, and basically all the trial court says is bank wins. So explain to me what reasoning the trial court utilized in determining that the bank should be successful on its claim for judgment on the pleadings.
Well, Your Honor, I believe the trial court understand and agreed to the argument I'm making here, which is basically the argument I made at the hearing. There are alternate requests for relief in the pleadings, in the cross-claim and counterclaim. Absolutely, that's true. And those are alternate requests for relief in the event the court did not agree with my position, then the bank was seeking alternate relief. But the court did agree with the position that the bank presented at the hearing, and this is the argument that I was making at the hearing.
Okay, so I'm struggling with how to review the trial court's analysis here. So perhaps you can help me, because the trial court actually said nothing except that you win.
Well, the trial court, the transcripts in the record, the trial court said that the court agreed with the bank's position. That's what was argued at the hearing, Your Honor. True, there were alternate grounds for relief, and had the court not granted that motion, this matter goes to trial, then that would be part of the case. But the trial court agreed with this argument, and so it didn't get to the alternate grounds for relief that were requested.
Okay.
I have a question, Mr. Kaiser. So the LLC is continuing to make flow payments, I guess, into the registry of court, but they're for the benefit of the bank for its judgment for the right to those payments. Is that correct?
The city's making the payments, Your Honor, the city and the utility.
Yes, sorry about that. But what about his argument that the bank's judgment is only limited to a certain dollar amount and more is being paid into the registry than the bank is actually entitled to?
What Mr. Harden said is the value of the collateral is $1 million. Of course, that's not in the pleadings anywhere. That's not asserted anywhere. That's Mr. Harden's argument today, unsupported in the record. If his client wanted to be at the sale and to outbid the bank, he was certainly willing to do so. He had the statutory notice that was required, and he could have appeared to protect his rights to the extent he believed he had rights, but he did not. But that's the comment about the $1 million. It's not supported in the record at all.
Was that argument made at the trial court?
I don't recall, Your Honor. Maybe, I don't recall honestly. Mr. Harden can address that, but in any event, it's unavailing because Mr. Ball had notice of the sale, but he did not attend or attempt to outbid the bank, which he certainly had the right to appear and do that, but he did not. Of course, he was in default on his note at that point anyway. There's nothing in the record that the bank would not accept direct payments. All the issues that Mr. Harden says need to be determined, remanded for trial and determined, have either already been determined or are irrelevant to this appeal. Now, let me also address the bank has requested damages under the frivolous appeal statute 27-1-122, where the court finds the appeal is frivolous. It can, on its own motion or the motion of a party, award damages against the appellant, including costs, interest, judgments, and expenses. In Jackson versus Aldridge, the court said an appeal with no reasonable chance of success is frivolous. The bank respectfully submits this appeal is frivolous. Based on the foregoing facts, Ball's appeal has no chance for success. Ball's position in this appeal is completely contrary to his agreements, including his representation and the contractual agreements in the security agreement, which he made to induce a federally insured banking institution to make a loan to him. Moreover, while claiming he's entitled to the Ball payments, Ball cites no claim or right whereby he can defeat the bank's ownership interest therein. The bank having acquired those payments at the Article 9 sale, which resulted in Ball's liability on the note being reduced to $0. I will advise the court that after this relief was requested at the end of the brief, after filing the brief, I filed a motion asking for the relief. Following that, researching another matter, I found a Court of Appeals case that said a request for frivolous appeal damages must be presented as an issue for review. I'm presenting that to the court as a matter of candor, but I'm stating respectfully that I disagree with that because the motion that creates the remedy itself for frivolous appeal damages says that that is brought by motion either of a party or the court. To the extent the court believes I'm wrong about this, I would ask the court on its own to grant frivolous appeal damages in this case. So in conclusion, I'm asking your honors to affirm the chancellor to declare that in order that the bank is entitled to be paid directly by the city and utility to the exclusion of Ball, the LLC, the trust, that all payments paid into the registry of the court so far and all future payments be paid solely to the bank, and that the bank be awarded frivolous appeal damages. Thank you very much. I appreciate the opportunity to bring this before the court.
Thank you, counsel. We'll hear from the appellant in the rebuttal.
Okay, just a brief rebuttal panel. Again, the reasonable inferences to be drawn from the pleadings.
Mr. Harden, I need you to do something for me.
Yes, Your Honor.
I'm glad you opened with your comment about reasonable inferences. Tell me specifically which facts are disputed that would, or which material facts are disputed here that would change the outcome of this case, or that would not allow the trial court to grant judgment on the pleadings. And you can also include what reasonable inferences you suggest should be drawn from those.
Okay. The key again, Your Honor, is what, based on the specific language of the loan documents, what does the bank have a security interest in? Mr. Ball, all he has to do is raise the issue for purposes of motion on the pleadings that it was not the direct, not the entire pot that comes from the city that should have gone or used to go to the LLC. So
what did they have a security interest in?
What ultimately would come to Mr. Ball after the money started with the city, then went to the trust, then went to the trust account, and then went from the trust account controlled by independent trustees to an account owned by Mr. Ball.
All right, and to make sure I understand, but Mr. Ball dissolved the trust.
In accordance with the terms of the trust, after the bank began making direct payments to Mr. Fielden. That's in the trust document, Your Honor.
So he could unilaterally dissolve the trust, which would terminate the bank's security interest.
No, not terminate the bank's security. Well, that's the difficult part of the whole case, is what is the security interest held by the bank?
I think I've asked that 4 times.
Yeah. And I think without expert testimony, all I'm saying is it is Mr. Ball's position that it is not the actual payment from the city that originally went to the LLC, which always happened, but how it ultimately got to Mr. Ball. Okay. So what I wanted to address in the reply is 2 quick things. Number one, this decision closely follows this court's decision almost a year ago today in the Culpepper v. Baker Donaldson case that held, and there you had a pro se litigant, and this court ultimately held that based upon the record, it wasn't ripe for motion for judgment on the pleadings. The other matter I wanted to address was the frivolous appeal claim. The bank relies on Jackson, which is a 1999 decision that is in no way apposite here, and our Supreme Court in 2010 and Henderson specifically said to support a finding of an award, the appeal must either be frivolous and devoid of merit such that it has no reasonable chance of succeeding, or is taken solely for the purpose of delay. Neither of those compelling factors are here present.
All right, Mr. Harden, your time's expired.
Thank you, Your Honor.
Court thanks counsel, both to all counsel for their briefs and oral arguments on this. Mr. Hibner, if you would, please recess court till our next case.
This honorable court is now in recess until 10:30 a.m.